Hello, welcome to February 13th, 2026, the day before Valentine's Day. Don't forget your people. This is Mark Walmer. I am the attorney who runs recorderacer.net. Our office is here to research criminal records, talk to people about what criminal records can be cleared and when, and then if a pardon is the appropriate solution, we prepare and file and track pardon applications with the Governor's Board of Pardons. In fact, we're in the middle of the Pardon Board reviewing about 120 cases Wednesday, Thursday, and Friday of this week. They're still going on in the background a little bit. And so this is just a live stream that we do. I think we want to try to create it and expand it so that people can feel free calling in and talking about criminal records. I guess it isn't calling in, it's chatting in or typing messages. But, we have absolutely no judgment about any criminal record. We understand that people shouldn't be judged by some of the worst decisions that they've had or made in their lives. And we also firmly believe that these criminal records were never meant to track people infinitely. And so that is what we're working on. I think somebody should, I'm going to go over some statistics, which is just filling dead air until we get some questions. But the Board of Pardons, as I said, they're in the process of reviewing. And I'm going to do some statistics about the reviews that they did Wednesday, Thursday, and Friday. So just to let you know what these reviews are, they're called public sessions. The public sessions are what happens after somebody has filed a pardon application. They've had the auditor call. They might have received an expedited questionnaire. They went through a merit review when the board voted, when the 5 board members voted, and 2 of the 5 had to recommend hearing more from this candidate. If they didn't get 2 votes to hear from the candidate is basically kicked out of line for a year. They have to wait a year, and then they're allowed to refile their application from the beginning. So that's where we are. If the person does get 2 or 3 or 4 or 5 votes, they're given a public interview, which is called the public session, which is what was going on Wednesday, Thursday, and Friday. And I have some statistics about that. And I guess just to cover where pardons fit into the record clearing landscape, pardons are the only thing that can remove misdemeanor or felony convictions in Pennsylvania. And that's it, unless you're 70. And the 70 exception is that if you've been off of supervision for 10 years, when you reach the age of 70, you can petition the Court of Common Pleas in the county of conviction to remove any felony or misdemeanor without going through the pardon process. So that's one thing. You need a pardon to get rid of any felony or misdemeanor conviction before you're 70. Another little update is the fact that pardons are currently taking between 5 and 10 or 13 years. It's not really clear. The Pardon Board recently had an influx. 6,000 applications were received in the past 3 years. Currently, the Pardon Board is only meeting 3 or 4 times a year. They've been reviewing 400 to 500 applications a year, and that's where that backlog comes from. And I'm just going to anticipate a question here, which is, do they still have expedited review? And what I can tell you is that the expedited review checkbox has been taken off of the application. And so the board does still have an expedited review category. The expedited review is for usually single docket misdemeanors, primarily marijuana, that is over 7 years old, and single docket marijuana felonies that are over 10 years old. They still receive an expedited review. exactly what that expedited review means in this 5 to 10 to 12 year process is not clear. It simply means faster. It would be faster than multiple dockets, violent offenses, multiple felonies, and all of those that go through the more extensive long-term process. I can also tell you that the average age of the pardons being reviewed by the board Wednesday, Thursday, Friday is about 4 years plus or minus, 4 to 4.5. And so for the rest of this year and then for next year, I expect the cases to be coming 5, 6, 7 years old until they're reviewed. And that's just the lay of the land for right now. So, having said that, Wednesday morning, the Pardon Board reviewed a total of 18 cases. They recommended 11 of them, and they did not recommend 7 of them. And so, again, recommended means now that they received at least 3 of the 5 votes. It means the application is sent to the governor with a recommendation that he give them a pardon. What does that mean? It means Governor Shapiro has the pardon on his desk. He probably does his own internal investigation. He doesn't have to do anything with it, but in general, I believe he has been issuing pardons or denying them within 3 to 6 months. But it is clear that there are occasionally times when he doesn't act on a pardon or does issue them, but in his own time. He seems to be a very busy guy. But anyway, for today, for the morning, yesterday, Wednesday morning, not yesterday, 18 total cases reviewed, 61% recommended, 39% not recommended. In the afternoon, they reviewed 20 cases, and 75% were recommended, 25% were not recommended. So this is not even a 50-50 process, but obviously it's not a 100% process either. Similarly, yesterday morning, they reviewed 18 cases. 12 were recommended, 5 were not, which means 67% received a recommendation and 28% did not. And yesterday afternoon, they reviewed 20 cases, 14 recommended, 6 not recommended, for a yesterday afternoon statistic of 70% approved and 20% not recommended. So for the 2 days, they reviewed a total of 76 cases. 52 were recommended, which is 68%, and 23 were not recommended, which is approximately 30%. So give or take, there's about a 70% process, not quite 3 out of 4, but not quite 2 out of 3, better than that. And so that's some statistics about what is going on right now. Today they are reviewing more cases, which they are not done reviewing yet. So they are reviewing 17 in the morning, and it looks like 18 in the morning, 19 in the afternoon, and we'll have those statistics for later on. So that's where we're at now. I'm wondering where I should look to see if there's any questions. I think I covered that. So just to review, questions about, do they still have expedited review? Yes, it seems to be single dockets, mostly marijuana, or single docket misdemeanors after 7 years, single docket felonies after 10 might be expedited. They might be expedited. The board is the one who reviews them and decides if they are going to be expedited or not.
I'm going to teach you other questions.
Okay. And what does the expedited process look like in the 5 to 10 or 12 year pardon process? It is not clear. It would be faster than the other cases, but how fast isn't clear. There's simply a very clogged pipeline right now. If you wanted to, for people that follow my channel or whatever, I'm going to frequently be doing call outs and saying, there's nothing wrong with you contacting your state senator or your state legislator, your representative, and saying, hey, Did you know that the pardon process is incredibly backlogged and that it's really taking too long for people to have access to the only legal procedure that can possibly forgive a misdemeanor or a felony conviction? Can you tell the Board of Pardons you'll do whatever they want to support them? Because you know what? April is Second Chance Month, and everybody needs a second chance if they have a criminal conviction. And so telling your public representative, your political representatives, that this is a priority and that it is very helpful to the employment, the housing, and the education of Pennsylvanians and other Americans certainly seems like a non-controversial position to take. And maybe some of these politicians are occasionally looking for a what? They're looking for a theme or a project that really can't go against them. Ever since COVID, keeping Pennsylvanians and others employed has been very important. Frankly, with the things going on in the nation nationally, employment's becoming more and more of an issue. And so I think keeping people employed is important. I think I'm going to pause here and tell people about the record eraser process, which is if you go to recorderaser.net and you fill out the form that's on the website with first name, last name, date of birth, email, and phone number, maybe write some comments like, I had a theft offense in 2010, it's still haunting me. We'll look up your record for free on the Pennsylvania UJS portal. We will send it to you with a link to look at it and booking link so that you can book 15 minutes to talk to me about your record, during which time I will tell you what can be cleared and when. In general, the way things are working now is if you need either a limited access petition, which hides a record, or an expungement, which blows a record out of the water but isn't available for misdemeanor and felony convictions. Those are referred to a statewide network of attorneys that I use to file petitions in their local courts of common pleas, because local attorneys are better at filing petitions in their courts. Any case that requires a misdemeanor or a felony pardon, we keep in-house. Our process is to write off to the clerk of courts to get the 6 specific criminal records that the pardon board wants to review. We create the pardon application for you. You would complete a 400 or 500 word statement about everything good you've done with your life and any letters of recommendation or letters of support that you want to attach. And we would get the pardon filed with the Board of Pardons so that you can forget about it. And then anytime the Board of Pardons wants to have a phone call with you, which would be 2, 1 would be an auditor's questionnaire that we will prepare you for. And the second is this public session like we just talked about. They're doing Wednesday through Friday of this month. And after that, we find out if you're recommended to the governor. And to put a bow on it, if the governor issues a pardon, your record will be automatically expunged by the state police without the need for any additional legal services. And so that was one of the improvements that was implemented by Clean Slate. Now I have a question here. My record was supposed to be expunged, but it's not. How can I get this off my record and get it expunged? A 1995 conviction. Well, I would say that first of all, let's talk about some of the complexities of the process. And it's going to be a word salad, but that's okay. You wrote in a question to a lawyer, and I'm going to answer it. My record was supposed to be expunged. 1, why do you think it was supposed to be expunged? Was it ARD, which is expungible, but mostly they don't expunge themselves? But frequently people that get ARD know that the result of ARD was supposed to be an expungible offense. And when they hear that, they think it's supposed to expunge itself. Then you might have a 1995 expungible case, but if in fact we can find it, we would send you to an attorney in the county of the conviction, and he would file an expungement petition, and that could be off your record in 3 to 5 months. So my first question about the question is, why do you think it was supposed to be expunged, or do you think it was expungible? Now let's talk about a complexity. When Clean Slate came through, part of the Clean Slate statute was a rule or an order or a law that the Pennsylvania State Police criminal computer is supposed to automatically seal or hide certain offenses. So when I say seal, you say hide, seal, hide, seal, hide. That wasn't supposed to be funny, but all of a sudden I pictured a baby seal up in the Antarctic, and that's enough of that. But anyway, the record sealing told the criminal computers to hide expungible cases. So somebody might be searching the UJS portal and they might not see their record and they might think that it was expunged, but it wasn't. It was just sealed. So the first thing to do is to find out if it was sealed or not. There's two ways to do that. One, you can call the clerk of courts in the county of, not conviction, but in the county of record, and you can ask them, was my record sealed? Different counties answer that different ways, but that's a free resource. The other way is to contact the Pennsylvania State Police and to ask them for a full access review criminal history, which will take a couple of weeks or months to get, but that should show you everything on your record, whether it's a conviction or not. We have a service where we write off to get Pennsylvania State Police criminal histories for $150. You can fill out a form on recorderacer.net. We will look and see if we can find it on the UJS portal, but as I said, if it's sealed, your hearing hidden, then we're not going to find it, but it could still be there. The answer is, if it is expungible, it needs an expungement petition in the county that the case took place in. So then the question was, my record was supposed to be expunged, but it's not. How can I get this charge off my record and get it expunged? And the answer is, first of all, find out if it's still on your record or not. Secondly, file an expungement petition. And if you want a referral to one of our attorneys to do that, fill out the form on the website or call in to 717-925-7820, and we'll be glad to refer you or help you out. If someone is denied a recommendation, do they find out why or what the applicant could have done differently? The answer to this is very frustrating because the Board of Pardons is very clear that their review of an application does not need to be explained in any way. Also, I believe the Board of Pardons has access to multiple databases of criminal records. I believe they have records from other states. I believe they might have access to police reports that regular people would not. It's also possible that the Board of Pardons has a social media research division and might be researching Facebook or Meta or whatever. And so sometimes when people are denied, they're denied inexplicably with absolutely no reason. And I don't know why. My clients want to say, why was I denied? Don't they have to explain themselves? And they don't. They will not tell you why. You can wait a year and then you can file again. I think in some cases, this is just my hunch. But for instance, Attorney General Dave Sunday believes that a pardon is an exceptional remedy, that he hasn't said this, but he has indicated that even 13 years of being crime-free is not a guarantee that you're eligible for this wonderful pardon, and it might not get his vote. Now, a vote that you don't get from him doesn't mean that he hates you. It means that he's one of the people that thinks maybe he wants to see 15 or 20 years of law-abiding behavior before he would give a yes vote. Again, this is all my speculation. They don't have to give a reason. Frequently, they don't. In fact, I had a case where a person was recommended to the governor unanimously, and the governor denied issuing the pardon with a one-sentence denial. And so not only doesn't the board have to tell you why, but the governor doesn't have to tell you why. It is one of the hardest no votes that you can get, and it's very demoralizing, it's very depressing, because the people are like, I didn't do anything wrong. I've been out of trouble for 10 or 15 years. They didn't even tell me why. All they're telling me is you can wait a year and then get in line again for a 5 to 10 year process. It's not satisfying, but it's the only game in town. This is a very unique practice area. I frequently compare it to being in the Wizard of Oz, being in Wonderland, and the wizard's behind the curtain. And I guess the difference is we never get to pull the curtain back and see the guy pulling the levers. And he actually had a conversation with Dorothy, so that was nice. But this is slightly different. And so that's that. Someone said, I had my hearing February 20th, 2025. I was recommended for a pardon. I still have not heard from governor, approved or denied. What should I do? Well, the answer is there is nothing you can do. Again, not satisfying. This would indicate it's been a full year since they were recommended for a pardon. The governor is not required to do anything. The governor has his own staff. The governor has his own agenda. It's in a black box. I don't know. I'd be totally guessing and speculating. Do you get a state senator or a representative to contact Governor Shapiro? I don't know. I can't recommend that. I don't believe anything political goes on behind the scenes. If it does, I've never taken advantage of it. I don't know about it. But then again, could it have opposite repercussions? Could somebody reach out and say, hey, what's going on with this? And Governor Shapiro decides, okay, well, I'm just going to deny it. If you want to know what my answer is today, I'm just going to deny it. I don't know. It's really the worst of all worlds because it's true limbo. You can't file another application because you've been recommended to the governor. The governor doesn't have to answer you. Could you write off to the governor's staff and say, hey, is there any input or can you give me any guidance on this? I think you could, but I would suspect you would get a form letter that says the governor is not required to take any action on a recommended pardon. And there you are, you're stuck. So I understand it's not rewarding, it's frustrating, especially if you're at 4th and goal, all right? You got the whole way through the multi-year waiting period, the public session, you got the votes, it's recommended to the governor, and now the governor is just like, I get the frustration, but there's literally nothing you can do but wait. Maybe hit your knees and just, have a gentle, calm spirit. Because hopefully, you're at 4th and goal. This is where it probably is a 50-50 game, although there are some statistics that says that the governor has been issuing 75% of the pardons recommended to him by the board. So maybe you're in the 3 out of 4 land, but it's frustrating. There's nothing you can do. And that's the answer to that. I did want to take a pause here and just say that one of the things that we're doing to try to keep our people on track as they enter this 5 to 10 year queue is we've started to branch out into helping people either with career counseling or finding jobs, trying to give them fresh ideas and fresh ways of moving forward. Frequently, people that have criminal records are told to go get a job without a whole lot of guidance. They may or may not know about Pennsylvania career links that are very helpful. They may or may not know about other career counseling services. And so all they know is they apply for a job, they get denied. There's also rules about how you get denied and whether you get denied in writing. They have to deny you in writing. They have to show you what they were looking at. If they don't do that, it could create an employment law situation that we're equipped to advise people on. We are also familiar with felony-friendly or misdemeanor-friendly referral employment websites that we can help with. So the takeaway is, at the beginning of this process, if somebody interviews with us, we try to help them get better employment so that they're able to get through the pardon process. Because the number one thing the board wants to see is, did you improve your employment? Did you stay out of trouble with the police? Did you stop drinking? Have you given up drug use? The board loves it when you can tell them when you last drank or did drugs, and they love it especially if it's over 7 to 10 years ago. So if employment options or counseling is anything people are interested in, please let us know. Let me know. I got a question about how do you prepare your clients for a public session? That's a great question. And as you know, I guess, I don't really know this, if you have been watching the public sessions, then you know what the interviews look like. And in fact, I'm going to do a list of questions which will answer that question. What I do is tell the people who's going to question them, what order they're going to be questioned in. I tell them to listen to the questions, and I tell them to respond very succinctly. And if they're not sure of their answer, to say, does that answer their question? Number two most important consideration for the board is that you are 100% honest and direct. Okay? So have good employment. They also like to ask if you've given back to the community. They want to know when you quit drinking or doing drugs. And those are things. But then I also go over sometimes, in fact, I think we're going to do a blog about this and maybe create another video. But just in the past 2 days of pardon public sessions, the questions that I'm witnessing being given are, if you had an addiction issue, are you familiar with what triggers you? What triggers you? They're looking for if you're aware of your psychological triggers that led to either drug use or criminal activity. What kind of support system do you have? Again, related to drug and alcohol issues. How many DUIs have you had? And the board will ask how many DUIs you've had, even if you're not trying to get a DUI pardoned. You might be trying to be clear an old 25-year-old felony, and if they see DUIs, they're going to ask you about your DUIs. One of the board members said, why should we vote to recommend a pardon for you? Tell us why we should vote. That's a softball. If you're coached correctly, that's one for you to hit out of the park, because you can immediately just tell them 4 or 5 sentences of everything good you've done with your life in response to why should we vote for you. A question of when did you quit drinking? What impact did your crime have on the victim? Are you showing victim empathy? Did you attend programming in state prison? And also, did you attend any kind of programming in the county prison? Have you had any contact with law enforcement since the crime occurred? That's something very interesting. Couple more. I think people need to have a list of their good points that they can pivot to whenever there's a lapse in the conversation. I think one of the things they should do is always point out, I was 18 when this happened, or I was 21 when this happened, and I was with an older accomplice. That was 20 years ago when I was 18. Give them a time frame. Remember, they're reviewing 40 people a day. These stories can just become repetitive. And if you have a chance, pivot to, well, that happened when I was 18, and since then I've rebuilt my life and focused on employment and family. Things of that sort. Have you used your experience to help others? Is a good one. What lessons have you learned? What are you doing to maintain your sobriety? Do you attend AA and NA? And again, as I said before, they like it when you engage in any form of community service, whether it's helping out in a food kitchen or joining a church to do a community drive or doing something like that, or even mowing your church's lawn or something. They love it when you give back to the community. Does working for yourself count as a better working history? I don't think it matters. They're interested in employment. My mother and my grandmother, and not in that order, my grandmother and my mother always used to say, idle hands are the devil's workshop. And frankly, we know in the criminal arena that many times people that are not employed actively and young and working multiple jobs, they have time to get into trouble. Or if they have a criminal record and they don't think they can find employment, they sit in the basement feeling sorry for themselves, and then they need money and they can't do anything but go out and deal drugs. That's the opposite of a good candidate. You got to pick yourself up, dust yourself off, get out there, start with minimum wage employment, even if it's flipping burgers, and then just work your way up. You can do it. Employers are out there looking for people. So if you, and many people have done this, I have many clients who were not able to get employment. Some of them go out and get their CDL. They drive truck for a couple of years, and several of them have then gone on to buy their own truck and created their own trucking company. Boom, the pardon board's going to love that. Become entrepreneurial. Other ones have not been able to get employment, or they worked as a carpenter's handyman or something, learned the trades, and then went out and started their own home remodeling business. That's great. That's entrepreneurial. The board doesn't have any trouble with that. It shows the initiative. It shows taking responsibility and moving forward. So you don't have to work for others to look good. I also have numerous clients that have become electricians. They went out, they used CareerLink, for instance, will teach you basic electrical. They'll teach you basic framing. And then, or you can go to a shop like here in Lancaster, Thaddeus Stevens, and go through a basic carpentry course. There's plenty of construction going on around the country. Start off, learn the trades, branch out on your own, start your own business. That's all good stuff. Employment is super important, which also answers what I can work on to become a stronger candidate. Employment, stability, stay out of trouble with the police, quit drinking or doing drugs, know your clean date, and just thrive. Just dig in and give back to the community. Did I mention that? How long should someone wait before even thinking about applying for a pardon? These are a couple of good questions here, and it's amazing to me how often I need to say, I don't know. So I don't know, but I'll give you the things that I think about, and then you can think about them too. On one hand, some members of the board think that even 13 years is too soon to think about getting a case pardoned by the board. All right. On the other hand, we know the pardon process currently taking 5 to 10 to 12 to 13 years. All right, well, there's two considerations. Then, how long ago was the offense? The more nonviolent the offense, the more it's a misdemeanor. In a certain way, if it's like a pot possession charge, even if it's recent, there's a part of me that wants to say get it filed, because if they're not going to review it for 5 or 10 years, throw your hat in the ring. A safer answer is to say, well, if it's a nonviolent misdemeanor, wait 5 years and then start the 5 to 10 to 13 year pardon process. But to that person who's already struggling with employment with a nonviolent pot misdemeanor, you're saying suffer for 5 years and then go into a pardon process that's going to take 5 to 10 years on top. So put your life on hold for 15 years. That's not satisfying either. One of the things I like to say about the pardon process is that you can't hear yes, you're pardoned, unless you're willing to hear no, you're not pardoned. Where you put yourself in that algorithm or that calculation of 5 to 10 to 13 year pardon process, but some small pot offenses and pot felonies can be expedited. But what does expedited mean? And if they're expedited and they're reviewed in less than 5 years, do they still need to be 7 to 10 years old? It's not clear. None of it's clear. And frankly, I don't feel bad telling people honestly that I can't tell them that they're guaranteed to get the result that they want, because I'm simply somebody who files pardons and watches whatever the board does. And the board themselves do not communicate very much. If they would put out guidelines, we would memorize them and follow them and frankly promote them and publish them. So it would be much better guidelines, but they don't do that. And this is simply, these are the cards you're dealt. This is the hand you're dealt. And I guess maybe one of the good things about us is we're always willing to have a candid discussion, a candid, non-judgmental discussion about what your odds are, because we don't want to quote people a fee and have them fail. But also, it's a fee for a service. And if people say, look, I can't hear yes if I'm not willing to risk no, and if you're talking about 5 to 10 years, I have to ask now. Well, then, as long as there's a good, candid discussion and they're aware of the fact that it's a process that's not guaranteed and actually does not have a refund either, people are allowed to choose what they want. Here's a good one. I like these questions. Can you apply for a pardon if you still owe fines or restitutions? That is a great question with a really recent answer. On one hand, Wednesday, I believe, and even yesterday, I heard the board saying, when they were taking their vote, one board member said, can I advise the board or make a motion that if the board wants to recommend a pardon, that it's conditional about fines and costs being paid off? And the board votes and they unanimously say yes, and then they vote and they recommend it for a pardon, but the pardon won't be issued until fines and costs are paid off. So that is what happened yesterday and the day before. But that person made it the whole way through the pardon process and still owed money. That's not good. And in fact, you should know if you owe money or not. That's going to lead to another answer. The reason why you don't know if you owe money, because I have conversations every day, and actually my team is great at finding out if there is unpaid fines, costs, and restitution, and then we send those messages to our prospects. And I frequently hear this, well, I was released from probation or parole, and they wouldn't release me if I still owed money. Wrong. Oh, but I can owe money because I had a traffic stop last week, and they would have taken me into custody if I still owed money. Wrong. If you're getting advice from a probation or parole officer, you have to pause for a moment. You have to be in charge of your case. You got a conviction. You went through probation. You can look up whether you owe fines and costs, and you need to establish getting them paid because of the next thing I'm going to tell you. And so fines and costs used to be discovered along the way, and then if they were paid off, you'd get the pardon. I've noticed recently with a couple of pardons that were filed where fines and costs were not paid off, and the board administratively dismissed the pardon. Sayonara. They don't tell you why. They never tell you why. However, it was a case where there was outstanding fines, costs, and restitution, and the fines, costs, and restitution would have been paid off within the near future. And so what I'm telling you is that I have a suspicion that maybe the Board of Pardons, if a pardon application is filed and they see that there's still a substantial amount of fines, costs, and restitution that's due and owing, I think they might be just dismissing them as a way of reducing that backlog. Remember, 6,000 cases in 3 years? They're going through 500 a month. They want to increase their throughput. If you owe fines and costs, you're starting off with a demerit. That might be something the Board of Pardons is doing. So get your fines and costs paid off first. The easiest way to do that is call county probation and parole. Ask them if there's any fines, costs, and restitution that's due, and get into a payment plan. Another comment I got was, well, look, I called probation and parole, or I was taken in to the judge and I was given time served, and time served is supposed to pay off all my fines, costs, and restitution. I'm not sure that's correct either. If a DJ sentences you on a traffic matter or a misdemeanor, that might give you time served on a small matter, but if you owe fines, costs, and restitution, maybe your time in jail goes towards your fines and costs. It's not going to pay off restitution. So it's your job to make sure of what you owe, get on a payment plan, get it paid off, and then talk about the pardon process. I've read on the pardon forms that someone with a PFA has to wait a mandatory 5 or 10 years before they will even be eligible. Is this true? Well, if you read it on the Pardon Board website, I would say it's true. I have not run into that position, but I do know that, as I've told you, they want to see a long period of time without engagement with law enforcement. A PFA is something that involves law enforcement. And so if you are getting involved in law enforcement within a 5 to 10 year period, it's easy to think that they would want to see 10 years of law-abiding behavior before they put you into the queue. I'm not personally familiar with that, but if you read it, I think what I'll do is have someone on my team go and see if they can find the comment about a PFA on the Board of Pardons website. If it says mandatory, that means yes, you must wait. All I can tell you is they want no involvement with law enforcement. PFAs are taken out because someone, the victim, believes that they were in danger of bodily injury or assault. And so that's not a good thing. And if the PFA became final, that's one thing. If the PFA was dismissed, that's another. All these things need to be taken into consideration. Here's a question. If the governor legalizes it, does that help change the pardon process? So in this question, what does it refer to? If the governor legalizes marijuana, does it help change the pardon process? I made up the word marijuana there. It wasn't in the question. If the government legalizes marijuana, then from the moment they decriminalize it, hopefully pot smokers will not pick up criminal charges anymore from that date going forward. That will not affect everybody that has a marijuana conviction for the past 50 to 100 years. Those people will still need pardons. Now, a secondary question. If the government legalizes marijuana, would the Board of Pardons possibly speed up or truly expedite the marijuana review process in a blazingly quick way? Yes, maybe. It would certainly be a green light that the legislature and law enforcement is not as concerned about marijuana as they used to be. So that's a consideration. Another question might be, if I filed for a pardon on a marijuana felony 5 years ago and it's in the queue and then marijuana becomes legalized, does it speed my case up? No way of knowing that. Mark, I have a question. If they pass a marijuana legalization statute, could the legalization statute say, oh, and by the way, everybody that has a simple single marijuana conviction should have their case expunged? It could say that. The legislation could say anything at once. I think because last year we watched them roll out Clean Slate 3.0. When the legislature wants to throw you a bone in terms of hiding a record, they have a tendency to seal the record, which means it still needs a pardon. So they could write a legalization statute any way they want. I'm not familiar with what might be being considered, and I've just given a very long-winded answer about what happens if they legalize something or other. It was dismissed before the 6 months, and I got a bit angry about the mother of my kids lying about dating a registered offender and them. Yeah, so now this, I think, applies to the PFA. So let's go back to the PFA. And the question, Molly or someone on the team, if you're watching, see what the Board of Pardons website says about a mandatory waiting period for a PFA. Because the question that I received from the questioner is, I've read on the pardon forms that someone with a PFA has to wait 5 or 10 years before they'll even be eligible. So now my question is, what does the word with mean? Does with a PFA mean that you have a PFA that became final, which is a much worser thing? Or does it mean if somebody was charged with a PFA that then was dismissed after 6 months, does that trigger the same ineligibility for 5 to 10 years? Well, no. If a PFA was dismissed or withdrawn, it means that there was not an underlying basis. There was not a finding of guilt or a finding of fault that became permanent. That means the PFA was a problem if it led to a final order. If it was withdrawn or dismissed before then, it's not indicative of anything. However, could the board still think, well, you were involved with law enforcement. We still want to hold it against you. I don't know. The other thing is, the worst that happens is you file for a pardon. Let's say you had a PFA against you. It was withdrawn or dismissed after 6 months. Okay. Let's say you file a pardon. The worst they do is dismiss it. If they dismiss it, you have to wait a year, and then you can ask again. But it's better almost to have the board dismiss your application than for you to sit there and say, should I disqualify myself for 5 or 10 years when the PFA wasn't even finalized? I mean, at some point, you need them to weigh in on it, not me, not you. And in terms of being angry about the mother of your kids, lying about this, that, and the other thing, you're just talking about the whole breaking of relationships in America and how the criminal system and the divorce system has been, weaponized to just turn parties against each other and use the children against each other. And believe me, as a lawyer with 40 years of experience, I am familiar and exhausted, but I understand it completely. So, now let me see here. Holy mackerel, it's what? Is it 12:48? That's more word salad than I put out in a week usually. Could you see the wait time for a pardon moving to 6 to 7 years? I like that. I have a very intelligent audience, and that's because you're living with this every day. So what I have been telling people, I am part of a team of pardon fellows that at the end of last year gave the board a list of recommendations for how they could speed up the pardon process. We have not heard back from the board to my knowledge. I don't even know if they will respond to a team of seasoned pardon filing professionals. But if they adopted some of those recommendations, yes, it would speed up the system. Also, if the board came up with a way of streamlining the system, there's rumors that the board has the ability to use AI in some way of expediting the review of certain applications. Could that speed things up? Yes. Also, one of the recommendations was for the board to meet more frequently. I think they're only meeting 3 or 4 times this year, and that's why they only get through 400 to 500 cases a year. What if they met every other month and they reviewed 120 cases every other month? Well, 6 times 120 is 600, 720 cases. So they're not catching up with the deadline, but they've sort of stopped falling behind it. What if they met every month? Are they ever going to be willing to do that? I really want everybody to understand the board is a part-time position. They have other things to do. Dave Sunday, or General Sunday, is the Attorney General of Pennsylvania. I guarantee you he has other things to do and dozens or hundreds of staff people to supervise. Lieutenant Governor Austin Davis, he's got a full-time job working with Josh Shapiro and doing all of his initiatives. Marcia Grayson, the new doctor that didn't even sit yet, they have full-time careers. And Harris Gubernick is a PhD working with the Department of Corrections. So they're doing the best they can with a constitutionally ordained process, but it does need to be sped up. We don't know all the ideas that they're going to come up with. We don't know what political pressure can be brought on them to try to address it. So the answer to the question is, could you see the wait time for a pardon moving to 6 to 7 years? Yes, I think that's a good goal. There's many involved in the process that think 2 to 3 years is too long to review, especially if somebody has waited 5 to 10 and then start the process, have it reviewed in 2 to 3. But when I'm quoting people, I need to tell them that there's a part of the process that I control and that there's a part of the process I don't control. That's why if currently we're looking at least a 5 to 10 year process, our focus doesn't change, but it branches out into other areas like helping with employment, helping with career counseling, helping with coaching. Employment number 1, no contact with law enforcement. Do you know what? If somebody has a criminal conviction and baby's mama is going to use it against him and the marriage is starting to fall apart and you know you have a conviction, at some point you have to say, do you know what? I know I'm going to ask for a pardon. I can see where she's going with this. I can't get hot. I don't want the police being called. I'm just going to get up and go. I'm going to remove myself from the situation. She doesn't need to call the police. You just got to keep things cool, because anytime the police show up, the pardon board's going to be watching, and it definitely does matter. Another question. This is entirely too much work on a Friday afternoon. I'm kidding. I don't really do anything but work. Juvenile records can be cleared, right? So, there's a juvenile expungement statute that says if you have a juvenile adjudication of delinquency, which is a juvenile conviction, and if you are over the age of 18, and if you have been out of trouble for over 5 years since your adjudication of delinquency, and if there is no pending felony or misdemeanor conviction or prosecution therefore, then you can file a juvenile expungement. So remember, expungements are usually only available for juveniles. If you've stayed out of trouble and all you have is a juvenile delinquency, yes, you can get that expunged. My problem is, or my challenge is, many people that are committing crimes when they're juveniles, either because they're poor or they're not growing up in great homes or they're learning how to live on the street, frequently turn 18 and then that conduct continues and they start picking up adult charges. When they pick up adult charges, it eliminates the possibility of filing a juvenile expungement. And in fact, we have started putting juvenile delinquency convictions on pardon applications because an adult conviction knocks out the ability to expunge a juvenile case. So, yes, juvenile records can be expunged if there's no adult conviction. If there are following adult convictions, it complicates things, and you probably need a pardon. Hope this is all clear. Somebody ought to write, these are really good explanations, because I can't tell if I'm just confusing myself or everybody else. Oh, come on, what's the difference between a pardon and an expungement again? Where are my paddles? Let's just try this. It's a Friday afternoon. Hope this doesn't make me look silly. What's the difference between a pardon and an expungement? Well, pardons are green and expungements are yellow. Clean slate's red. Okay? Here you go. Expungements are for juvenile records if there's no adult conviction, for summary offenses that are more than 5 years old, for underage drinking if you're over the age of 21, for charges that were brought and every docket that was brought was dismissed, withdrawn, or null pros. There is no conviction related to it. Or if you got ARD for a first time drunk driving or some other offense, ARD is probation without conviction because they're not misdemeanor or felony convictions. All of those can be expunged. If you have a misdemeanor or a felony conviction as an adult, you need a pardon. Unless you're 70, because once you're 70, you can expunge it. But until you're 70, misdemeanor and felony convictions need a pardon from the governor. But, Mark, I've heard that some misdemeanor and felony convictions can be hidden with limited access petitions. This is clean slate. We need to make more words that say limited access. Here's the confusing thing about the difference between clean slate and limited access. Clean slate is the part of the Clean Slate statute where the computers were told to go automatically hide certain records, which sometimes it has and sometimes it hasn't, and nobody knows why. That's clean slate. Limited access is the part of the Clean Slate statute that allows an attorney to file a petition in the Court of Common Pleas to hide a case if it was not automatically hidden by clean slate. Okay? And every misdemeanor or felony that can be hidden with clean slate or limited access still needs a pardon, because clean slate will hide it from some employers and landlords, but the conviction is still there with the state police. And so you need a pardon to remove the convictions that remain after limited access petitions hide it. And so that is the difference between pardons, clean slate, and expungements. Is that clear? it's what we deal with every day. But anyway, that was some good paddle fun there. And so now it is 12:57. That's a full-on hour, a little bit. So somebody's typing a question here. I'll do one or two more. I think Molly was typing something. No?
No.
Well, she ought to.
If you have any other topics you want to cover.
I just talked myself. Oh, a little bit. Just a little bit. Dr. Williams is no longer the medical doctor on the Board of Pardons. There's a new doctor. What is it, Dr. John O'Brien? I think it's John O'Brien. Dr. O'Brien, the part of the Board of Pardons mandate is to have a medical doctor on the board. So Dr. Williams' term expired. Dr. O'Brien was nominated by Governor Shapiro and ratified by the Senate last week. Dr. O'Brien was not able to come up to speed with the 120 cases that were being reviewed Wednesday, Thursday, Friday of this week, but he was sitting there taking notes and being very attentive, and so I would expect that he will be available and sitting on future pardon public sessions, which we will promote. What dates those are, I think the next one's in March or April, but we will certainly be promoting them. It does raise a little bit of a question because during the most recent public sessions, there were only 4 board members. Since you need 2 votes in favor of your case to move forward, some people were denied because they didn't get 2 votes. But the question is, if there were 5 board members sitting, would that have changed the odds of them getting 2 votes? And is there anything that can be done about that? I'm not sure there is. The statistics change a little bit differently depending on whether all 5 are sitting or not. But in any case, Dr. O'Brien should be sitting after January and moving forward. I think that's all I wanted to. Oh. Yeah, and by the way, feel free to post comments or silly comments. I'm aware as an older man that sometimes my use of words is, a lot of the times people don't understand the references to my use of words or the things that they refer to. Like, for instance, when we used to say all the time that somebody's being mollycoddled when they're pampered, and people don't know what mollycoddling is or where it came from. I have personal experience with that. But anyway, I love language. I frequently look up people's last names and where they came from when I'm talking to people I'm interviewing, just because I love language and things like that. So if I'm using phrases you don't get, or if you need something defined, or if you want to educate me about this, that, or the other thing, I hope nobody's getting their feelings hurt. And so I understand all that. And so from February 13th, 2026, the end of 3 days of public sessions, from the team here at recorderacer.net, also known as PA Pardon Service. Stay in touch. We'll keep doing these and go forth and conquer. Carpe diem. That means seize the day, from Latin, that lawyers talk.